The elements of a contract comprise the criteria that establish a legally binding agreement. As previously discussed, a contract must be enforceable by law to be deemed valid. The elements of a contract are offer, acceptance, consideration, and intention to create legal relations. Contracts invariably commence with an offer, which is a manifestation of an individual's inclination to enter into an agreement based on specific terms. It's crucial to differentiate between what constitutes an offer and what does not. Offers must be explicit and not open to interpretation or ambiguity. The individual making the offer is referred to as offerer. In Olaupa v. Obafemi Awolowo University, the university invited an architect to a meeting to discuss the use of its property for commercial purposes. During this meeting, the architect presented designs and sketches, which he subsequently submitted to the university along with a bill. Following the university's refusal to pay, the architect initiated legal proceedings. Both the trial court and the Court of Appeal ruled that there was no offer. An offer refers to a specific action or commitment made by one party with the intention of finalizing the agreement as soon as it is accepted by the other party involved. An offer can be made to a person, a group of people, or to the whole world. In the case of Carbolic Smoke Ball Co. v. Carlo Bowen LJB, asserted that it's possible to make an offer to the entire world, and any interested individual could accept the offer, thus creating a binding contract. An offer could be express or implied. An offer may be said to be implied in certain situations. A good example is where a person enters a shopping mall, selects an item, and proceeds to engage a cashier. It's possible that the cashier may implicitly accept the customer's purchase request by processing the transaction without verbal confirmation. The offer may also be expressed if the offeror tells the offeree the terms of the offer. Invitation to treat. In contract law, an invitation to treat serves as a preliminary step in negotiations and does not create any legally binding obligations. An invitation to treat is not legally binding in itself. As opposed to an invitation to treat, an offer typically comprises the fundamental terms of the proposed agreement and indicates that no further negotiation is necessary. Some examples of invitation to treat: auctions, as was in the case of Atabage v. Cond; display of goods for sales, as in the case of Pharmaceutical Society of Great Britain v. Boots; cash chemists; an advertisement of goods in a catalogue; invitation to tender. The solicitation of bids by an auctioneer does not constitute an offer but rather an invitation to treat. The bids themselves are considered the offers, and the acceptance happens when the auctioneer's hammer falls, as established by the precedent set in Payne v. Cave. The auctioneer has the option to decline bids during the auction. However, if the auctioneer decides to accept bids, they are obligated to accept the highest bid and finalize the transaction once the hammer falls. When goods are displayed in a shop, the trader has not made an offer. If anything, he has only invited the customer to make an offer for the products for which the trader would accept. Essentials of a valid contract. T must be communicated. The action undertaken should have the objective of securing agreement from the other party. Establishing legal relationships requires a mutual exchange of consideration. Offer must be definitive and devoid of any ambiguity. Acceptance of an offer. Once the offeree accepts, a contract between the offerer and offeree is established, and the terms of the agreement become legally enforceable. It's worth noting that an offer can be accepted through verbal communication, written correspondence, or implicitly through the conduct of the offeree. For instance, suppose John offers to assist Mary in relocating from her apartment for $20 and Mary gives John the keys to her apartment for him to commence the move without explicitly accepting the offer. In that case, we can infer that Mary has implicitly accepted the offer. Termination of an offer. An offer can be terminated by death of either party, revocation, lapse of time, and rejection. If an offeree is aware of an offerer's death, they cannot accept an offer made while the offerer was alive. However, Should the offeree be unaware of the offerer's death and the terms of the contract can be fulfilled by the offerer's estate, the acceptance is valid. An example would be the payment of a sum of money. In Bradbury v. Morgan, it was established that the offer did not expire due to the aforementioned reason. In cases where the offer requires the personal performance of the offerer, such as writing a book or singing a song, the acceptance is invalid. Should the offeree pass away without accepting the offer lapses. This was the case in Kennedy v. Thomason. It's important to note that an offer can be withdrawn any time before acceptance, notwithstanding any prior assurance to keep the offer open for a specific duration. This assurance is only enforceable if it is supported by consideration. In Routledge v. Grant, the defendant retracted their offer to purchase a house after 3 weeks despite granting the plaintiff 6 weeks to accept. As the offer was revoked before acceptance, the court ruled that no legally binding agreement was in place since the plaintiff did not provide any consideration for the promise. The circumstances would be different if the obligation to maintain an open offer is supported by consideration, thereby prohibiting the offerer from revoking the offer. This principle was exemplified in the case of Mountford v. Scott, where Scott granted Mountford an option to purchase his residence within 6 months in exchange for a payment of £1. The court ruled in favor of Mountford, stating that the offer was irrevocable. The revocation of an offer must be communicated either directly, as was seen J.N. Byrne v. Van Tienhoven, or indirectly. An offer may be deemed terminated after an appropriate lapse of time without acceptance. If the offerer sets a specific time period, it must be adhered to. However, if no time period is specified, a reasonable duration will be inferred based on the unique circumstances of each case. The court would evaluate the facts and circumstances to determine a reasonable lapse of time. For instance, in Ramsgate v. Montefiore, the offer to purchase shares expired after 5 months due to the lapse of time. Similarly, in Loring v. City of Boston, the offer of a reward for information leading to the arrest and conviction of arsonists published in a newspaper expired after a period of 3 years. An offer is considered terminated once the offeree has rejected it. Until it has been communicated, rejection does not terminate the offer. Therefore, if an offeree changes their mind, they may still accept the offer as long as the offerer receives notice of the acceptance before being notified of the rejection. In our next lesson, we will continue with acceptance as an element of a valid contract. Don't forget to like and subscribe to this channel.